All rise. We will obey. Please be seated. We
are in open session, Your Honours.
Thank you very much. Mr. Steinberg, please proceed.
Thank you, Your Honours. When we took the tea adjournment, I was finishing my response on the issue of the witness's health, and I just pointed out that the VW is mandated to take care of all issues relating to the health and welfare of witnesses pending their testimony. And the prosecution's recommendation, Your Honours, is that if the Chamber is entertaining any doubt as to the fitness of this witness to testify, then he should be referred to the VWU for a proper assessment, an independent assessment. I do understand that the VW psychologist is on standby, who should be able to examine the witness as regards any issues of depression and to give a report on whether or not that would affect his ability to testify. Further, it is normally standard before the witness's travel, as I understand it, for the VW to take the witness to a doctor for an examination, and that can also be done. Moving on then to the second point raised by Mr. Mutai, and that is that he had not been provided with any statement of the witness, which he says is necessary for the purpose of taking instructions from this witness. I will deal with the second part first, and this, of course, begs the question, as I raised earlier, Your Honours, take instructions for what purpose? The prosecution is still unclear as to the reasons and the purpose behind Mr. Mutai's representation of the witness and the proposed appointment of senior counsel to represent the witness. Mr. Mutai has not pointed to any provision of the statute or rules by which he claims to have right of appearance for that purpose before the court. I note that the Chamber has permitted him to make submissions regarding whether or not the witness is able to testify. I presume that is due, Your Honours, to the terms of the summons served on the witness, which calls upon him to appear on today's date or to show good cause why the summons to appear cannot be complied with. And for that limited purpose, the prosecution takes no issue with Mr. Mutai's right to address this chamber for that limited purpose alone. Over and above that, Your Honours, the prosecution submits that Mr. Mutai or whoever is to appear with him needs to make out a good cause under the statute and rules of this court as to why they should be granted an audience to represent the witness and for what specific purpose. As far as I'm aware, Your Honours, the only purpose provided for in the statute is for representation under Rule 74 in circumstances where a witness may be at risk of self-incrimination during the course of his or her testimony. Now, we do know in advance of the testimony of this witness that he has recently deposed to an affidavit under oath in Kenya, which contradicts portions of the statement that he has previously given to the OTP. It may well be under the ICA that an offence may have been committed in the process. There are many provisions of the ICA which refer to the giving of conflicting statements, to perjury, and to perverting the course of justice. So, for those reasons, the prosecution does not see, the prosecution does anticipate that the Rule 74 may be engaged in this case. I note that VW has also provided a duty counsel who is present today for the purpose of representing the witness under Rule 74. And again, the prosecution would seek clarity as to exactly who is to represent this witness and for precisely what purpose.
I want to make sure that I understand your submission. Are you saying that, yes, the witness may have deposed to an affidavit in which not only is there the potentials that the witness may have, maybe deliberately giving conflicting information, one in a statement to the OTP, and a conflicting version in an affidavit, not merely a statement, in an affidavit. As well, certain specific allegations made against the OTP in the affidavit, and those are averments in an affidavit about what he claims the prosecution was doing with him. And you're saying that in spite of all those considerations, you do not see Rule 74 may be engaged in this case. Is that what you're saying?
No, on the contrary, Your Honours, I'm saying that because of that, I see that Rule 74 may well be engaged in this
Oh,
case.
right, then you may have been.
If I apologise if I didn't express
Oh,
myself
right,
clearly.
I think it's probably you started saying something and then you changed, switch gear, said something else. So it's now clearer. You are saying that that may well be.
Indeed, Your
All
Honours.
right, good.
And, I mean, obviously the prosecution denies the averments made in the affidavit, so to the extent that those are made under oath, should they prove to be false, that's another reason why Rule 74 may be engaged.
Does that then not engage the possibility or the reasonableness of counsel attending the testimony of the witness on his behalf?
Yes,
Oh, with him at the time.
Your Honours, it would. For the limited purposes of Rule 74, I just want clarity as to whether that is indeed the case. Because if we know that that is the purpose, then the role of counsel is delimited by Rule 74. And the reason I'm concerned is that there's talk of counsel obtaining...
The statements, all the statements of the witness.
Well, more than that, Your Honours, obtaining phone records and basically obtaining evidence to produce to the court.
President, I apologise for rising. I do so I look at the monitor and it seems to have frozen. I wanted to make sure that there's not a technical problem, that at least audio is being relayed to Nairobi.
Is it back on for you now?
No, it's frozen.
Because mine is moving along quite well. Judge Fremad's also frozen. Okay.
Mine is frozen too, Your Honour.
Mine wasn't frozen. Maybe it's a privilege of presiding judge.
Mr. President, this is the courtroom officer in the VTC location. I confirm that we can hear you loud and clear. For us, the image is perfectly running and all seems to be running okay. We don't experience any difficulties from this side. Thank you.
Your Honours, I think for the purpose of my address, it's probably not necessary for the pictures to move. So if I may, I propose to proceed. I'd like to then just reply to my learned friend's statement at page 14 of the record.
So, stay 1 second, please. Well, Mr. Steinberg, it is important for us to try and ensure that Nairobi is with us because they will be responding to your submissions or rather replying. They have the right to reply. So let's check, see.
Dial again. Hello? Okay, we're going to redial. Can you just redial again, please?
I see that we're back on with Nairobi.
Very well. May I proceed, Your Honour? I was turning to the submission by my learned friend Mr. Mutai at page 14, line 11, regarding the provision of statements to him, where he said that despite, well, I'll start a bit earlier on. Now, the other reason why we're not ready to proceed at this particular moment, Mr. President, and the Honourable Court, is that we've not been provided with statement that the witness is said to have given to the prosecution. That is despite the fact that in their first communication to us, the OTP did promise to avail all such necessary documents. Your Honours, I'm afraid that that is simply not correct. The first, not only in the first communication, but in any communication, but the first communication to which my learned friend refers was sent via the OTP information desk on the 20th of August 2014 in response to receipt of the email in which the client's recanting affidavit was attached. And I will quote as follows, but I will replace the name of the client simply with the reference to your client. Dear Mr. Mutai, the Office of the Prosecutor acknowledges receipt of your letter dated 11 August 2014 and the documents attached. We note your client's stated wish to withdraw as a prosecution witness. However, please be advised that Trial Chamber 5A of the ICC has already issued a summons for your client's appearance before the court via video link from, I won't mention the location.
Mr. Mutai, do take care when you ruffle the paper. It may be necessary for you to do so. And just to remind you that when you do that, there's a lot of feedback and noise when you shuffle your paper about. Just to let you know.
Apologies, Mr. President.
Thank you, Your Honour. Via video link from the court in Nairobi at 0800 local time on the 1st of September 2014. This summons has been transmitted to the Kenyan authorities, who under the ICC Rome Statute and the Kenyan International Crimes Act of 2008 are obligated to serve and, if necessary, enforce the summons. We understand that your client is aware of the existence of this summons. Therefore, notwithstanding the purported recantation of his original statement, your client will be required to attend and testify. Since you have indicated that you act for your client in this matter, may I suggest that you apprise him prior to his testimony of the consequences of providing false evidence before the court under Article 71A of the ICC Rome Statute and or under Part 2 of the Kenyan International Crimes Act. You may also wish to advise him of the provisions of Rule 74 of the ICC Rules of Procedure and Evidence, and I'll slow down, relating to self-incrimination. The ICC documents are available on our website. For our records, we would also appreciate being advised once this is done. And then this is probably the relevant portion. Members of the ICC Victims and Witnesses Unit, an independent unit of the registry responsible for witness security and logistics, will attempt to contact your client in due course to make arrangements for his transportation to court, if necessary, and other incidental matters. We have also provided them with your details for this purpose. Finally, it is usual for witnesses to meet with lawyers from the OTP prior to their testimony for witness preparation. Please advise whether your client would be willing to attend such a preparation session. If not, the VW will provide your client with the necessary explanations of court procedure and the opportunity to familiarize himself with his previous witness statements, and then the normal salutations. So clearly, Your Honours, the prosecution never promised to forward to Mr. Mutai copies of the witness statements, nor would we, since these are confidential documents and are only to be shared with persons who have been admitted as counsel before the court and are thus subject to the confidentiality and disciplinary regime of the court. Of course, as soon as, if it may be the case, as soon as Mr. Mutai is appointed as counsel, and should the Chamber, in its discretion, deem it to be appropriate to appoint Mr. Mutai or any other person who may be wished to be briefed as Rule 74 counsel, we will immediately avail them of those statements. In fact, copies of the statements have been provided to the Victims and Witnesses Unit, and they stand ready to do exactly that. The reason why, well, I should probably place on record that as far as I'm aware, the witness has not yet had an opportunity to go through his prior statements. And this is because, despite arrangements being made by the VWU last week for the witness to travel to Nairobi for the purpose of such preparation, he did not so travel. I understand that he only arrived in Nairobi either late last night or this morning. The prosecution's view is that the witness should be given an opportunity to review his prior statements. My learned friend, Mr. Mutai, has not responded to the prosecution's question about whether or not he would be prepared to consult with the prosecution. But in the absence of any such agreement, I do not claim or I do not argue that he's obliged to do so. But in the absence of that, if he chooses not to consult with the prosecution, I submit that members of the VWU should at least be given an opportunity to go through the statements with the witness.
Mr. President, I do apologise for rising. There was an application, and I must confess, and it may be my dimness, that I'm having difficulty following my learned friend's submissions, because I don't know, is he seeking to object to the application, or is he not objecting? And that very simple statement will help understand the submissions that are being made. But it seems on certain issues, we're going in, if not in circles, there's a bit of ambiguity, and I'd ask that we get a bit more precision. Of course, my learned friend can elaborate, but it would be very helpful to know, is he opposing the application or is he in favour of it? And that would help me understand and follow where my learned friend is going. And that's my humble request.
Stand back, you can help Mr. Ken, the request is making.
Yes, it can be done that way. I was dealing with the legal issues first and then going to come to a conclusion, but I can state up front that the prosecution opposes a request of an adjournment for 21 days. The prosecution will submit, and as I'm in the process of doing, that such a lengthy adjournment is not warranted on the basis of the submissions made by my learned friend. What the prosecution does say, however, is that a more limited postponement may be necessary for two purposes. Firstly, in order to allow the witness an opportunity to review his prior statements, and secondly, for VW to do an assessment, an independent assessment of the witness's ability to testify.
And how many days of an adjournment would you propose for those purposes?
Your Honours, my brief instructions from VW was that they would take approximately 2 days for their normal processes, 2 to 3 days, in fact, I think I said. I see that there are representatives of the VW who may be able to speak better to that than I can. Your Honours, I would say that a postponement to either Wednesday or Thursday this week would be reasonable. Just a few more observations, Your Honours. I note that Mr. Mutai has alluded to the possibility of the witness appointing senior counsel to act on his behalf. I think it's obvious that anybody else who's going to be added to the team, if the Chamber deems that to be necessary, will also have to go through the same process of being admitted as counsel before the ICC. I'm not aware whether the senior counsel referred to is already admitted, but if not, then those processes need to be made. I would question, Your Honour, the necessity of the witness, of the appointment of senior counsel or silk for the purposes of a Rule 74 representation, however. I alluded briefly earlier to what my learned friend Mr. Mutai said about the necessity of obtaining various records that the witness wishes to provide to the Chamber. And it's unfortunate that throughout his address, many of the submissions made would appear to be more relevant to the representation of an accused person rather than a witness. There is no need for the witness to defend himself. The witness has been summoned to testify about certain events that happened back in 2007 and 2008. That is the main focus of his evidence. Obviously, things have happened since then, which culminated in the provision of an affidavit recanting his earlier evidence, and those will have to be examined. But it is for the parties, for this chamber, to lead evidence and to cross-examine and put questions. It's not for the witness to embark on a evidence-producing mission of his own in my submission. The issue of the passports, Your Honours, is, in my submission, the proverbial red herring. The sequence leading up to the provision on the 11th of...
Mr. Steinberg, before you embark upon that leg of your submissions, on your last point before that, the record from the telephone company, is it within the realms of possibility that you may ascertain the objectives of those documents? Have you spoken to that already? The M-Pesa record, sorry.
Well, only to the extent that I questioned the necessity of counsel's involvement in producing such evidence.
Yes.
I mean...
What I was about to ask is it within the realms of possibility for you to ascertain, or for us to ascertain, the purport or the potential objective of that sort of material, to see whether you can make any admissions, if necessary, that may obviate the need for M-Pesa records to be produced. Maybe when Mr. Mutai speaks in reply, he might address the point of M-Pesa record, what the witness had in mind with it, to see if it is something that the prosecution may well say, well, we have no difficulty, yes.
Yes, I imagine that is a prospect, Your Honours. As far as OTP payments to the witness via M-Pesa, we have those records. We've provided those and disclosed those to the defence in accordance with Chamber's earlier order. There are references to payments made in his latest statement. These would, in the prosecution's belief, be payments that would have been made by the Victims and Witnesses Unit in their ongoing care of this witness and in preparation for travel to the Hague. But it may well be that we can reach some agreements in those regards.
So your point is you're not denying that payments were made to this witness by M-Pesa?
Not at all, Your Honours. What we are saying is that any payments that were made to this witness were regular, above board, and necessary, and reasonable.
Proceed, please.
Thank you. As regards the passports, I note that initially in Mr. Matai's submissions, he indicated that the prosecution had taken the passport away, but in fact it has emerged that this was the VWU. This is entirely normal, Your Honours. VWU will speak to this, I'm sure, but obviously for the witness to travel to The Hague, visas are required, a Schengen visa is required, and that visa has to be put in the passport. It is standard practice for all witnesses who are to travel to The Hague that they would have to submit their visas to VWU for the purposes of obtaining a visa.
But why was that necessary in this present circumstances where the witness wasn't traveling to a Schengen region?
Your Honours, as I was about to inform the Chamber, there is something of a history to this matter which I think I should maybe just lay out. Subsequent to the issuance by the chamber of the summons for the witness, or at least subsequent to the decision to issue the summons to the witness got in contact with the prosecution through the field office, its field office, and requested whether it would not still be possible to testify voluntarily. Now, Your Honours will be aware of the fact that you had also encouraged the prosecution to examine ways of getting the witnesses to testify voluntarily. And indeed, we engaged with the witness, met with the witness. He confirmed that he was ready and willing to travel to The Hague to testify voluntarily before the court. For that reason, we set in motion the normal process of handing the witness over to the Victims and Witnesses Unit, and for that reason, they met with him on the 4th of August. I haven't taken instructions, but I imagine that that is the time when his passport would have been handed over for the purposes of getting a visa to travel to The Hague. Now, the witness was due to rendezvous with the Victims and Witnesses Unit on the 10th in order to commence travel to The Hague on the 11th of August. On the 10th of August, having told the unit that he was en route to Kenya, he did not arrive for the meeting, and the following day we received the affidavit sent to us by Mr. Motai. So that is, in a nutshell, the sequence of events. And the relevant investigators' notes have been disclosed to the defense. I speak under correction. My learned friend informs me that, in fact, on the 3rd of August, the witness gave his passport to one of our investigators, who then passed it on to the Victims and Witnesses Unit for that purpose of the visa. Now, the Victims and Witnesses Unit...
So the witness did voluntarily give his passport. The OTP did not seize it from him?
That's correct, Your Honour. Well, I might add, of course, that all of this happened in Kenya, where the OTP has absolutely no powers of seizure or search or arrest or any coercive powers whatsoever. The only way we can operate there is with the cooperation of the witness. The witness was supposed to, well, he would have got his passport back, obviously, on the 10th had he met with the VW, which he didn't. Again, arrangements were made by the VW last week, I believe it was on Thursday, to travel to Nairobi for pre-testimony assessment. Again, he failed to do so. Therefore, the first opportunity, I imagine, the VW had to return his documents was, in fact, this morning when he arrived at the court. So there is nothing untoward in that regard. There are no implied threats. There is no coercion. It was simply standard procedure for dealing with a witness to be transferred to The Hague. Your Honours, I think that pretty much covers it. So in sum, we would suggest that the testimony of this witness stand down for up to 3 days for the purposes that I've outlined, subject to whatever my learned friends from the registry and the Victims and Witnesses Unit has to say, and of course my colleagues in the defence.
On that matter-related matter, not squarely within the realms of the present debate, but still related to it, if the witness's testimony is postponed to 2 or 3 days, as you request, how does that affect the testimony of subsequent witnesses? Do you have them lined up to appear?
Your Honours, the prosecution is unfortunately in no position to line up witnesses, but my understanding is that later today there will be a formal notification from the registry to the effect that summonses have been served on 3 of the 4 remaining witnesses for this session, including the following witness, who is due to appear on Friday. Obviously, the delay in the testimony of this witness will have a knock-on effect on the other witnesses. But my submission is that if we have a witness who is ready, fit, and willing to testify, we should take that witness's evidence, and any other witnesses who do arrive pursuant to their summons can simply be bound over by the court until a subsequent date.
So that's it for your submissions?
That's it, Your Honor. Thank you.
All right. Mr. Naratsetsen.
Thank you, Mr. President, for giving us this opportunity. I will make my submissions briefly. We oppose Mr. Mutai's request, and I will make 5 points following the 5 grounds raised by Mr. Mutai. The first one, the medical one. Your Honor, basing your decision on the medical report submitted by Mr. Mutai will be deficient in our opinion. Of course, we are not in a position to challenge the merits of the medical report. And by making these submissions, I do not mean any disrespect towards the doctor who issued this medical report. But, Your Honor, we are concerned by the process during which this medical report came to your attention. Your Honor, as you, Mr. President, have raised this morning, we are alarmed by the inconsistency which reveal Mr. Mutai's communications with your Honorable Chamber. And we were also extremely alarmed by the last minute, the manner at the last minute Mr. Mutai submitted this medical report to you. Your Honor, maybe I might appear overly cynical, Your Honor, but to me personally, this seemed to be a last-minute attempt to delay the proceedings further, Your Honor. Therefore, we find Mr. Mutai's submissions and the medical report he submitted somewhat unconvincing and unreliable. Therefore, Your Honor, in these circumstances, we would invite the Honorable Chamber to obtain a second opinion by appointing an independent medical professional, as suggested by the prosecution, probably from the experienced professionals working within the witness unit. Your Honor, this concludes our first submission.
But in fairness to I follow your submission so far, but in fairness to the doctor who issued the medical certificate, the doctor didn't say that the witness may not testify. The doctor only said to avoid stressful situations. That's not exactly the same thing.
Yes.
Although, of course, we understand Mr. Mutai's submissions, but the fact remains that it's something that the doctor said and something the doctor hasn't quite said.
Your Honor, I understand. I'm in complete agreement with you, Your Honor. That's why, I said, we do not challenge we are not in a position to challenge the medical doctor's report or recommendations he made, but we are concerned by the timing of the submission, which, in our opinion, this medical report should have been made available to you much earlier if this was one of the grounds that Mr. Mutai was going to support his application for deferral. Yeah. Secondly, Your Honor, I would, just to be logically coherent, I would address the third point before the second one. Your Honor, Mr. Mutai says that, his client wishes to appoint a new counsel. Your Honor, under the provisions of the ROM statute, witnesses simply do not have an unqualified right to appoint their own counsel. We have to say the obvious here, that this witness is not on trial. And for the purpose of exercising, allowing this witness to exercise his rights, in particular his right against self-incrimination, we believe that the registry's appointment of a duty counsel, who is just placed to sit next to this prospective witness, he is sufficient for that purpose. Your Honor, as far as we know, the ROM statute and rules and procedure evidence do not provide any unqualified right to any witnesses to appoint their own counsel. Therefore, Your Honor, this brings to the next issue. Either Mr. Mutai or the senior counsel that this witness wishes to appoint, Your Honor, simply there is no such right. And even if Your Honor are mind to grant Mr. Mutai's witness, appointment of a new counsel will further delay these proceedings if in case that the new counsel would have to need another 24 days to familiarize himself with the materials in question. Your Honor, I see that there is some disagreement between the prosecution and Mr. Mutai about the provision of certain materials, Your Honor. Even in case that either Mr. Mutai or, if Your Honor's mind to grant his request, either a new senior counsel is appointed for this witness, we believe that regardless of the provision, the date of the provision of these materials in question, the request for delaying the proceedings so another for 21 days is excessive, Your Honor, excessive. The next point, Your Honor, Mr. Mutai says that witness wants to produce certain evidence, including foreign records and etc. Your Honors, as I said, witnesses do not have rights to present evidence. This witness is not on trial. The Rome Statute, the Rules on Proceeding Evidence, and Appeal Chamber's judgment on the matter, and Your Honor's decision, Your Honor, on the conduct of the proceedings, those decisions and statutory provisions are clear, Your Honor. Witnesses do not have independent right to produce evidence. The right to produce evidence, the lead evidence, that right belongs only to the parties and exceptionally to victims, which Your Honors leave in order to assist your chamber to arrive at the determination of the truth. My last point, Your Honor, there has been also some allegations about putting this witness on a stressful situation. Your Honors, I'm not giving credence to Mr. Mutai's allegations by making these submissions, but whatever the case, those allegations are speculative in our opinion and without any factual support. Even if this witness finds himself in a stressful situation, Your Honor, in our opinion, that's normal. The court proceedings are stressful for anyone who is involved, especially for the witnesses. In our observations, since the beginning of this trial, there hasn't been a single witness who hasn't experienced some level of stress. Your Honor, therefore, we submit that whatever the situation be, whether this witness finds himself in a stressful situation, that alone does not justify, again, deferral for 21 days, and in somewhat has nothing to do with Mr. Mutai's request seeking deferral. Your Honor, in conclusion, we submit that Mr. Mutai's request is without any legal basis and lacks factual support. If Your Honor is minded to grant his request, we still believe that the deferral of the proceedings for 21 days is excessive. In cases that Mr. Mutai or the new counsel that the witness wishes to appoint, we believe that maybe a deferral of starting from a few days, extending to, let's say, several working days, will be sufficient in our respectful submission, Your Honor. This concludes our submission. Thank you.
Thank you. Defense.
Mr. President, Your Honours, I'm most grateful. I'm opposing the application put forward. But before I go into details of that, there's no submission, there's no basis in my respectful submission for alarm, as my learned friend for the victims has stated on a couple of occasions. Indeed, it's a very positive day. And I think it's only right and proper to publicly applaud Mr. Mutai for honouring and respecting the summons and the orders of the court and appearing at the time and place required by the bench.
As should be the case.
Your Honour, of course that should be the case, and that's what I'm saying. It's to be applauded, particularly given that there's been an issue of quite some debate and, of course, anxiousness, anxiety on that part of the prosecution and the defence about what would be happening today. Your Honour, it's also right to say, as I'm in public, I applaud the witness. We've said repeatedly we want witnesses to come voluntarily to speak the truth. And so the fact that the witness has come to the place designated and to appear in compliance with the court order is something we, on behalf of Mr. William Ruto, thoroughly applaud, as does Mr. Ruto. Your Honour, Mr. Ruto is here, in court. He has, from the beginning of this case, done that which has been required of him. It is important in assessing this application to note that it is a year this month since this trial started. And throughout that process, Mr. Ruto has been cooperating, and we, for the defence, have done whatever we can do to try to expedite matters, because we want this issue resolved as soon as possible. And the merits of this application must be viewed against our right to a trial, an expeditious trial. We do not want delay, inordinate delay, or any type of delay. Your Honour, also, I do note for the record, I have heard today, for the first time, from the prosecution, not from the registry, that 3 out of the 4 other summonses have been issued. Again, I applaud the Republic of Kenya for serving those summons. I haven't heard it from the registry, I've heard it from the prosecution, but I hope that cooperation, once and for all, will silence what we say is the unfair narrative that the prosecution has been pushing for far too long, that there is an obstructionist government in Nairobi. That is denied, that is rendered false by the facts and the utterances of my learned friend today. Now, Your Honour, despite the fact that I applaud the cooperation of the witnesses, we do not, in our respectful submission, see merit in the application for delay. Of course, my learned friend has done what he is able to do in the time allowed, but as far as the medical evidence is concerned, even taken at its highest, there is no indication that the anxiety or tension that is complained of will ameliorate in a month or even 3 months. That being the case, the balance in our respectful submission is the same as Your Honour, the presiding judge. It's in the interest of the witness to get it over as soon as possible, because there's no indication that pause, delay, prejudice to the defence and waste of court time will offer any benefits to the witness at all. Your Honour, on the issue of instructions, and of course I accept that a witness like this, given that the prosecution has been constantly talking about its powers to compel attendance and arrest, and today other provisions have been prayed in aid by my learned friend that I don't wish to go into, dealing with the International Crimes Act, which we say are thoroughly spurious, they're specious points.
Mr. Ken, before you proceed, while you've raised the matter of prosecution, it looks like so far so good in your submission. There is an agreement between you and the prosecution opposing the application, but the prosecution says that in principle and for practical reasons that in the circumstances there should be a delay for a number of days, 2 or 3 days, to enable the VWU do what they need to do normally.
Well, Your Honour,
do you share the same?
Well, not exactly, not exactly. Your Honour, the witness familiarisation, in my respectful submission, is a red herring. This is not a witness like many others that come in from the cold, so to speak, are facilitated, contacted by the prosecution, have their transport facilitated, and they come to the court cold, as it were. This is a witness that has a duty counsel and another legal representative. It's a witness that is not in a foreign country and in a foreign court, but somewhere in Kenya, and in a room. It doesn't seem to be a very big room, but it's a room. Your Honour, I think, and we've seen it many, many times with the 21 witnesses that have testified, is very able to put the witness at ease. The bench is very able to tell the witness who is asking questions. This is the prosecution and this is the defence. So that familiarisation programme, we shouldn't follow it mechanically simply because it is there and may assist. It needs to be dealt with, even familiarisation, on a case-by-case basis. And when I put that against the delay, I'm not sure it's actually an imperative. If it's possible, if there's no harm to it, no problem, but it shouldn't be raised as an issue to delay the commencement of this witness's testimony. Your Honour, of course, Mr. Ruto is not only keen to have this matter and the whole trial concluded as soon as possible, so we can get into the stage of making submissions as to the merits or otherwise of the prosecution's case, and whether or not there's a case to answer at all, or whether or not the case should be dismissed. The other aspect is Your Honours have required Mr. Ruto to attend for the first 5 days of every session. And Your Honours, we have, I make no secret about it, he has very important duties to do back home. I don't want him hanging around The Hague while the prosecution or the counsel for the witness do things which are not absolutely essential. And in our respectful submission, Your Honour, this trial can start, the witness's testimony can start even tomorrow. And if I can go forward, I'll explain how. Your Honour, I'm not convinced at all with the prosecution's position that it is not able to give the statement to my learned friend, Mr. Matai. I'm grateful. Mr. Matai. It doesn't stand analysis. The prosecution have a right to give their statement, and in fact even a duty according to the litigation and the proofing and all the rest of it that they entered into, to one of their witnesses. Your Honour, if they can give it to an unrepresented witness, why on earth do they say there is some impediment preventing them giving a statement to a witness that's represented? This is not a case of third-party evidence, the evidence or the statements of Mr. X or Mr. Y. This is the case of the prosecution giving the witness his own statement directly or through his counsel. And in my respectful submission, it is unfortunate, to put it mildly, and without a proper legal basis, to withhold the statement from that witness. So that can be given today, I submit.
Yeah, well, thank you.
Your Honour, that can be given today.
That can be given today, but how can they be on towards? Was the prosecution bound to release statement to anyone who writes a letter saying, I represent X, and then the prosecution gives a statement to any lawyer who claims to be a witness counsel? Today we have the witness in court, and we've seen the lawyer standing next to the witness, and the witness has said, yes, this is my lawyer, at least impliedly said so. Doesn't that create a different scenario from what is obtained up until this morning?
Well, Your Honour, with respect, perhaps I can put it this way. If the prosecution had concerns that Mr. Matai was the properly appointed lawyer, that could be the case. But at the very least, as of now, as of today, when we have seen Mr. Matai, together with the witness, that argument, that alleged hurdle vanishes. It does not exist, and there is no impediment, we say, to giving Mr. Matai the statement and allowing him to go over that statement with the witness tonight. Your Honour, it's only a 32-page statement. It's only 32 pages. It needs to be gone through. I don't object if it goes the witness goes through it, if he wishes. But similarly, I eschew a mechanical approach. If the witness doesn't wish to see the statement, the witness can commence his testimony. If he wishes to see it, of course, that can also be given. But, Your Honour, when it comes to the issue of legal representation, and I note that since the break, a representative from the VPRS Council Support, Victim Council Support, has joined us, as well as the Chief of the Council Support Section. But, Your Honour, I've had the great honour and privilege of interacting with the Council Support Section for many years now, and I am aware that Mr. Esteban Peraltas and his office, on occasion, do give provisional, enter people provisionally on the list of counsel. Your Honours, I don't know if the full material, the full documents have been received by that office or not. I think perhaps they may not have been received, but be that as it may, that can be overcome. If that office, if my learned friend, the Chief of the Council Support Section, deems it appropriate, my learned friend, Mr. Matai, could be added in 2 minutes, provisionally assigned to the list of counsel pending greater scrutiny. So that hurdle also could vanish with a bit of pragmatism and a bit of willingness to make sure that this trial is not thwarted, goes forward in the interests of justice, in the interests of the truth, and not least the interests of Mr. Ruto. Your Honour, in relation to the senior member, Your Honour, my learned friend, Mr. Matai, of course, can hear and see us. It's a matter for the witness, of course, but what my learned friend, Mr. Steinberg, says is correct. The witness is not an accused. The witness is not a suspect. The only thing, in my respectful submission, and this is what I think any counsel representing any witness needs to be primarily focusing the client on, the witness on, the only obligation upon the witness is to be told, tell the truth. Whatever the truth is, you tell the truth. And if you lie, if you deliberately tell untruths under oath, not in your statement to the prosecution or your affidavits domestically, if you give false testimony under oath, Article 70 of the Rome Statute is there in the background to punish, because that could amount to a perversion of the course of justice that we very much deprecate. That's the primary duty of counsel, and my learned friend, in my respectful submission, does not need 21 days to inform the witness of that. Your Honor, I'm not saying this is a unique investigative opportunity where the principles of Article 56 could come in to ensure that we deal with this more expeditiously. But, Your Honours, we have a very great interest, and we've said it from the beginning, from my first application that 9 or 8 key witnesses be called at the beginning of this trial to get to the bottom. And I said then, Your Honours, it's not rhetoric, and I hope the bench will recall it. I will be judged not by rhetoric and saying that every day this trial continues is a miscarriage of justice, but by reality. And that's why we want this witness to be heard. We say the witness can give evidence tomorrow. If CSS extend cooperation and admit my learned friend to the list of counsel, that will allow Mr. Ruto's time not to be wasted unnecessarily, for him to fulfil and discharge his responsibilities to the court, hear the witness, allow the witness to be tested, and allow him to go back also and serve 40 million people in Kenya.
Mr. Khan, does the witness or counsel, whichever one may eventually appear to the counsel for the witness, do they need to also take into account any potential for difficulty that a sworn affidavit may pose? There is now a sworn affidavit in which the witness not only says, well, what I said may have said, but whatever I said to the prosecution was not correct, but also say that, yes, the prosecution did 7 specific things with me. All those deposed to in an affidavit. Is there a difficulty there that counsel for this witness may take into account? And if there is, do they need 21 days to deal with those difficulties?
Your Honour, the way I would answer it is this. There may, of course, be difficulties in any case, and sometimes cases that seem very simple are not. Cases that seem very complex, if they're boiled down, can be simpler than appear at first blush. So I'm not going to arrogate to myself that omniscience that I simply don't have. My learned friend, Mr. Matai, will be in a better position to make submissions on that. But what I do say is that at its highest, 21 days is not justified. And what I'm saying, Your Honours, is, of course, if the bench was minded, and if, so to speak, our ducks were lined up in a row, that my learned friend, Chief of the Council Support Section, granted Mr. Matai provisional admission to the list of counsel, and if my learned friend, Mr. Matai, then went over the statement today, in fact, it can be given to him right now. It's there in that room as we speak. Mr. Matai can go through it if your court orders it and allows him to have physical possession of it right now, so lunch is not wasted. Your Honours, then what can happen is, in the course of testimony, if difficulties arise, Your Honours are in command. You have your hand on the rudder, so to speak, and if Mr. Matai makes an application for some reason that additional time is needed, he needs half an hour to speak with his client, Your Honours, at that stage, bearing in mind the issue, can consider the application. But, Your Honour, just this massive period, because all these days add up, this is not the first delay in this case. There's previously been, from the very first opening speeches, a prosecution application to delay. There's been other applications to delay. We don't have witnesses to fill this space. And 1 day, 2 days, 3 days, 21 days, it all adds up to massive delay, inconvenience to the defence, expense to Mr. Ruto, he pays for his own travel here, expense to the Republic of Kenya, they have certain security responsibilities, distractions from certain core constitutional responsibilities, and we say we can step back and we can balance these competing requirements and start trial at the latest tomorrow morning. And, Your Honour, what is needed is your order from the bench that Mr Mutai can be given without delay the witness statement that is there in that room as we speak. He can go over that from lunch, the rest of today, start tomorrow morning. CSS can consider provisional assignment. In my respectful submissions, nobody has raised any issue that Mr Mutai is a member of the Kenyan Bar. Provisional assignment can be granted. Your Honours can start hearing the evidence. If in the course of that there are any difficulties, the bench at that time can make the appropriate ruling and give the appropriate relief to ensure that the rights of the witness are respected, as well as the rights of the prosecution and the defence. Your Honours, I'm not even insisting that we start at 2:30, because I actually could take that that position, that in these circumstances, let's start afternoon. I'm saying balancing this as objectively as I can, bearing in mind my responsibilities as lead counsel for Mr Ruto, and trying to be cognizant and understanding of the concerns of Mr Mutai. There's no justifiable reason on earth, we say, why this case cannot start 9:30 tomorrow morning at the latest. 3 or 4 days to the prosecution may not seem much. My learned friends for the prosecution, of course, have the advantage. They are staff members of the prosecution. They are here. They're paid to be here. They're employed here. Their contracts of service allow them to be here. Life goes on for them. Your Honour, it doesn't go on for the rest of us. It doesn't go on for Mr Ruto. There is prejudice, clear prejudice, and we say that militates against granting the relief. We say this case should should continue. This witness should commence evidence at the latest tomorrow morning. And that's our very strong and sincere submission, which we respectfully submit balances the requirements of justice on all sides. I'm grateful.
Thank you. Mr. Akin Kafa, you see that we have 15 minutes to a lunch break. I don't wish to rush you. I'm just pointing that out so we can see whether we can make progress. But I did not rush any of the other councils, so I'm not rushing you.
Your Honour, I should be able to finish my submissions within the 15 minutes. Your Honour, my instructions in respect to this application for adjournment is first of all to express the position of Mr. Sang that we are ready to proceed and would have really wished to proceed from today. Your Honours, we have, however, listened to what Mr. Mutai said in his application for adjournment, and we do not consider it unreasonable. And in the circumstances, Your Honours, we do not oppose his application for adjournment. We, however, have concerns about the period he is asking for. We observed that he initially had asked for 21 days. In the course of his submissions, he seemed to want to extend the time to 30 days. We think both the 21 days and the 30 days he alluded to are unreasonable. If we were asked, we would say a period of approximately 14 days would be reasonable for him to cover all the areas that we can anticipate he needs to cover.
Can you pinpoint us to those areas that would justify the 14 days? What it is, the difficulties that, in your view, he is facing that you think would warrant an adjournment for 14 days?
Yes, Your Honour. The first one, as the prosecution has alluded to, is the fact that he gave the prosecution an initial statement. There is an affidavit where he has bordered on recanting on what he had said. And I think there is need to advise him as to whether there is any consequences to that. More particularly, and I think this needs to be clarified, whether there is any obligation on him to stick to what he had initially said. The second issue, Your Honour, is...
would we need to have 14 days for that?
The basis of the 14 days, Your Honour, is for Mr. Mutai and whichever counsel is referring to look at all the statements. The Rome Statute, as we are aware, he confirms that he is not yet in the list of counsels and probably is getting himself familiarized with the Rome Statute for purposes of this case for the first time. And so I'm taking into account all that. And Your Honour, if you think the 14 days is too much, I leave it to the hands of the judges. It is my assessment that 14 days is reasonable. my suggestion of 14 days is a very subjective assessment, and we quite clearly would say that it is an issue for you to determine. And we would leave it to you, Your Honor. I think we are all agreed, except Mr. Khan, that probably Mr. Mutai and his witness needs time, and it is just a question of how much time he needs. Your Honor, you had asked me what items there are that he needs to take instructions on. So that is one. The second one, Your Honor, is that there are issues which have been raised in the circumstances of this case which border on Article 70 matters, Your Honor. I think it is also an issue that he needs to take instructions and to advise his client on, Your Honor. Your Honor, on the issue of one of the items that Mr. Mutai made reference to, sorry.
Do we need to worry about Article 70 for purposes of the testimony of this witness?
In a very limited sense, Your Honor, that if it were to be the case that in the course of his testimony, the prosecution put questions to him which border on him having to say something that can come back to him under Article 70, then he needs to be advised on, Your Honor. That is the sense in which we are making reference to Article 70. We, however, take the very strong position that Article 70 issue should not be conducted in these proceedings, and that the chamber has already made a determination on that issue that it should go to the pretrial chamber. That is our position, Your Honor. It is only our concern that questions could be put to him, and in the course of answering it, either cautiously or unconsciously, he makes an answer whose effect is to put himself in a prejudice in respect to any subsequent or likely Article 70 proceedings. That is the sense in which you are making that point, Your Honor.
Can such be taken into account in an Article 70 proceeding? Can't it? What's said on the stand on the protection against self-incrimination?
Your Honor, our position would be that he needs to be advised on the point, regardless of whether it can be, regardless of the arguments around the question as to whether it can be used in prosecuting him or not. Your Honor, that would be our position on that issue.
All right, proceed.
Thank you, Your Honor. Now, Your Honor, there is reference as ground number 4 by Mr. Mutai that he needs certain documents for purposes of for purposes of his witness, or rather his client's testimony. Your Honor, as a side issue, and since the issue has come up, we would like to make the following observation, Your Honor, that on the 12th of August 2014, we wrote to the prosecution on our own initiative on the Sanks case, asking for disclosure of funds that may have been paid out to him. The prosecution told us to inquire that from VWU. And we did make that inquiry to the VWU on the 24th of August 2014, and the VWU said that they are under no obligation to disclose any payments that have been made to the witness, and that if we are strongly minded to get that disclosure, then we should approach the chamber. Your Honor, that response is from VWU dated 25th of August 2014. And I thought I should just mention this, Your Honor, as an issue that may be related to what Mr. Mutai has made reference to, although we made our application completely without notice of the existence of this. Your Honor, we propose to have filed our application by Wednesday, seeking an order from the chamber to have the VWU disclose any payments that have been made to this witness. And I thought I should just highlight that because it's relevant to this issue. the witness requires the assistance of counsel. That doesn't seem to be the issue. It would seem, in an analysis of what they have submitted, that their concern is the choice of counsel. And, Your Honor, we would submit that this witness is entitled to choose his advocate or his counsel unless there are very compelling circumstances that necessitate the need to take away that choice from him, Your Honor. And I'm saying this with reference to the very pointed submissions made by the Mr. Naratsetse, that this court can impose on him a counsel, Your Honor. Your Honor, we do not necessarily disagree with that, but we would submit that that is an exception rather than the rule, that you would need to have compelling reasons why the chamber thinks that Mr. Mutai is not the appropriate person to represent him and to impose on him a different counsel.
If you have two lawyers in circumstances in which Mr. Khan has said, we want to proceed immediately because every delay impacts on the right of our client to speedy delay. And the prosecution also says, we want to proceed almost immediately with a little time given for the VWU to do its protocols. In those circumstances, you have two lawyers. One says, I need 21 days, possibly more, because we may retain external counsel who may need more time than that. On the other hand, there is another lawyer who says, I don't need that much time. I'm prepared to proceed immediately. Does that count?
Mr. President and Your Honors, it does count, although that was not necessarily what I was submitting on. Your Honors,
you were submitting about circumstances in which the court may impose counsel on the witness, apart from the one the witness may choose himself.
Yes, Your Honor. I seem to have understood the prosecution and Mr. Naratsetse to suggest that the counsel that should represent the witness should be probably the duty counsel. And that is the sense in which I was saying that as in terms of the choice between the duty counsel and Mr. Mutai, the witness should be given an initial opportunity to make a choice of a counsel to represent him. However, I can go further and answer the question that you've posed, being, I suppose, the reference to the lead counsel that has been referred to. It is my submission that the issue of the lead counsel is irrelevant. If this chamber determines that they are giving this witness 3, 4, 5, or 14 days, Your Honor, it is the business of the witness and whichever counsel to make sure that they fit into that time frame. And so it wouldn't matter that another counsel would come and say he needs another window of time to get ready. That would be my submission on that point, Your Honor.
But do we have a concern to worry about out of due diligence? If you have two lawyers, one says, I am prepared to proceed in 2-3 days, whereas the second one says, I need 21 days, but if you force me to proceed in 2-3 days, I can give it a shot. In the circumstances, do we have a reason to choose one or the other? And which one would make more sense in those circumstances?
By way of extension of the concerns for the witness under Article 68, Your Honor, his psychological and health concerns, I would still submit that he should be given the first chance, Your Honor, with a clear timeline, and the counsel should not be allowed to come back and say he needs more time, Your Honor. And I have particular reference, and I suppose that's what, Mr. President, you are referring to the issue of the lead counsel. My understanding is that in Mr. Mutai's, if you give the time imposition on Mr. Mutai, he should be ready to come back and be ready to proceed. We haven't heard from the duty counsel, and we are not presuming that he has indicated that he's ready this afternoon or the day after to proceed, Your Honor.
We will be asking him that question.
That's okay, Yona. We will deal with it when it comes up. Now, the last two issues I wish to say, Yona, is there is this issue of the health situation of this witness keeps coming up. Yona, Mr. Steinbach has gone as far as reading closely the medical report with a view to making the observation that the conclusions made in the medical report are subjective. And, Your Honor, we would concede very readily that, in fact, it is subjective. But we would also go on and submit, Your Honor, that in almost all, it's almost invariable that in all psychological analysis, Your Honor, the determination of a doctor is subjective, Your Honor. You can't say there is, okay, at least more instances than not, the determination of the health condition of a psychological patient is subjective, Your Honor. So the mere fact that a subjective conclusion was made by a doctor in this case is no reason to say that, in fact, he's not suffering from the predicament that he is said to have suffered. And we would agree with the prosecution and probably the victim's representative that it may be better to have a second opinion. And we would also concede that we do not mind the VWU participating in that determination. We would, however, on our part, and of course subject to what Mr. Mutai will say in his submissions, that the witness could be also given a window to have a doctor of his choice accompany the VWU in making that determination so that there is fairness on the part of all parties. Your Honor, may I be allowed to just make these two last observations? The first one is that this is the first time we are seeing the prosecution criticizing their own witness. In the past, if they had witnesses who even have the remotest sense of any medical condition, they have been very ready to accommodate them and even to extend the indulgence. And so it surprises us that they border on criticizing this witness, his counsel, and the doctor who made the report.
This is a witness, is it not, Mr. Kigen-Katwa, who has submitted an affidavit saying, I no longer wish to be a witness for the prosecution. And in fact, the prosecution was up to no good when they dealt with me. And you are expressing surprise that the prosecution will want to insist that the witness proceeds instead of taking the witness's word for it, but he's not prepared to proceed.
Your Honor, the issue is not whether or not the witness wants to proceed. I didn't understand the issue to be that, Your Honor. Or rather, at least my submission is not that issue.
That is the issue we're dealing with now.
Well, the issue I was referring to, Your Honor, is just the criticism that has been leveled against this witness, who, as far as we are concerned, remains a prosecution witness. Your Honor, however, I'm ready to proceed to the last point that I wish to make. Your Honor, I must say also that I would like to congratulate Mr. Mutai and his witness for receiving this summons and being prepared to come and testify, Your Honor. And unless there are extremely compelling reasons, Your Honor, we would pray that they be accommodated so that the testimony can proceed. Thank you, Your Honors.
Thank you. It is now past 1 for lunch and break. 1 minute. We will be adjourning for the luncheon break to return at the usual time, Mr. Khan. In the meantime, when we come back, the VWU and the CSS will make submissions, but we'll do that after the lunch break. What we will direct from the bench at this time so that we can save some time is the VWU is directed to now the witness is in Nairobi to begin their process ordinarily with the witness, the familiarization, providing the witness with the witness's statement, just the witness for now. We will make a determination later on whether any other counsel needs to be given access, but at least in the meantime, the witness is entitled to his statement, and the VW should now kick in motion its usual protocol. And the chamber also directs that the witness be subjected to a medical examination by the VWU's own medical services people, doctor and psychologist, as the case may be. We will be needing the report of that medical examination for purposes of the decision eventual decision we'll make in this case, or whether or not to grant Mr. Mutai's request. So we want those things to be in process immediately so that we don't waste time later on dealing with them. The chamber will now adjourn and we'll come back at 2:30 and then take the rest of the submissions.
All rise. We will.